Good morning, everyone. Welcome to our compliance webinar today. Let me just get on the right screen here. I'm Ann Lavelle, and I know, just seeing everybody's names here, I know a lot of you. Welcome back. For those of you who don't know me, I practiced law as a management side labor and employment attorney. I was a partner in a very large firm downtown for a couple of decades. Decided that I wanted to have a life. And no, I decided I wanted to spend more time with my family, which seemed like a good idea until all four kids were home with a snow day the other day. And no, it's still a good idea. And retired from doing that. And I knew CTR in my prior life, and I always enjoyed the educational aspect of the law and helping people to learn it. So I was very pleased to be able to do this for them and to provide training sessions. For those of you who are new, normally we do these training sessions the second Thursday of every month at 11 a.m. For those of you who do know me, this is our second training session this month. So I know you're all saying, how can you get this lucky to have two compliance seminars in 1 month? But when some major things happen, we do like to try to do it in real time. And so that's why we accelerated this compliance seminar. And we're having two this month so that we can talk about these leave laws that we're covering today. As a side note, these compliance seminars are recorded and they are posted to CTR's website. Along with the slide deck, you'll get a copy of that. So if you missed something, you want to go back over something, this is our roadmap for today. Hopefully it helps you to easily find what you want to review. And again, you'll have all this information. It does take us a little bit of time to upload everything, but it'll be on there very shortly. Also, if anybody has ideas for future seminars, please feel free to reach out, or webinars, I guess I should say. We do about quarterly in-person seminars, which are a lot of fun because they're interactive. But if you have topics that you want to see covered, please let me know or let your CTR rep know. And we're always looking for ideas and want to talk about things that are important to you all as you're in the trenches there. All right, moving forward. Why do we care right now? Why are we covering this as a second compliance seminar in the middle of January, whenever these things have been around for more than 2 years? The city of Pittsburgh came out with their leave law first. Allegheny County followed. And we're going to go over those laws or those ordinances so that we all have a good foundation as to what they say and what they require. And then we'll work through a couple of examples. But why now? Well, the city of Pittsburgh, a week or two ago, issued a statement that said, we're done essentially being nice. That wasn't exactly their words. They said instead, it's strict enforcement now. We've been nice up to this point. When we've gotten complaints, we have educated employers. We've helped them comply. We've posted all sorts of materials on our website. But you employers don't seem to have your act together. So we're going to strictly enforce this law at this point. And then they went a step further and said, not only are we going to strictly enforce it for when we get complaints, but we're also going to take the initiative and start doing investigations, which is really common for government agencies to say, not only do we handle complaints, but we also take proactive measures and we sort of randomly investigate folks too. And so the city of Pittsburgh announced that it was going to start with certain industries. And if you're in the food service industry, lucky you, that's their first targeted industry. And in fact, they said they are going to start with certain zip codes. So the zip codes they mentioned were 15201 and 15203. If you're sitting here and you're in the food industry and you happen to be in those zip codes, you're first on the list for their targeted investigations. It doesn't mean they're going to look at everybody in those zip codes, but it means they're moving forward. And then, of course, they'll move on to other zip codes within the city of Pittsburgh. They also said we're starting with the food industry, because they think that industry has the most violations. It's the lower wage industry, has high turnover. Sometimes the managers aren't well educated about what's required under the law, all that good stuff. So for all those reasons, they're starting with the food industry, but they also said, hey, we're not limiting ourselves to the food industry. We may look at other industries too. So if you're outside of the food industry and you think, oh, great, I can now tune Ann out because I'm not in the food industry and I don't have her yap for the next hour. That's not quite the case. That's just an industry they're starting with. They aren't limiting themselves to just that industry. So that's why we're talking about it, because it's a good time if we know that they're on an enforcement role, so to speak, we should know what they're looking at and what we need to do to comply. So the first two things I want to point out are wonderful resources. So when you're looking at things, these websites, and again, you'll get a copy of these slide decks, have everything that you could possibly want to know, or all the information that we have at least, with respect to the Allegheny County Paid Sick Leave Ordinance, which I'll refer to as the PSL throughout this seminar, and the City of Pittsburgh Paid Sick Days Act, PSDA. They have guidance. They have FAQs. In fact, the City of Pittsburgh conducted its own webinar where it took questions from the attendees, not all of which would be applicable to everybody, but it was very interesting to see what their opinions were of certain things and to know that they are trying to provide resources for employers to comply with. One thing I want to mention here, let me see. Oh, you're quite welcome. Somebody just said, thanks for offering these. You're quite welcome. I love doing these. I love talking. You guys are the only people who listen to me. My kids sure don't. So, no, I'm joking. It's a cold day. I guess I'm in that mood. But if you have a question, feel free to put it in the Q&A or the chat. I do monitor that as we go through this webinar and try to answer everybody's questions as completely as I can. All right. So those are great resources. And in fact, they have the required posters on those resources. We'll talk about those in a little bit. So great websites to know about, to look at. Maybe even watch the City of Pittsburgh webinar. If you're in the City of Pittsburgh and you're in the food industry, might be a good thing to spend 45 minutes looking at. All right. Who should care about these two laws? And we'll see that these two laws basically mirror each other. There's a couple of differences that I will point out, and that starts with who's covered. But more or less, these laws, if you comply with one, you're going to comply with the other. So in Allegheny County, the business doesn't have to be located in Allegheny County, which throws off a lot of people. A lot of people are like, oh, I'm in Butler, I'm in Washington or Armstrong, wherever. I don't need to worry. That's not true. That the test is not where the employer is located. The test is whether or not you have a certain number of employees, with at least one of them spending some time in Allegheny County. So for the Allegheny County sick leave law, you have to have 26 or more employees. We'll talk about who is an employee. You'd think that would be a straightforward answer, but it's not. And at least one has to spend some time in Allegheny County. For the City of Pittsburgh, it's a much lower threshold. It basically covers any employer who has one employee floating around in the City of Pittsburgh. If their employer is over 15 employees, the accrual cap for hours for time off is 40. If the employer has less than 15 employees, the cap is 24 hours for any employee who's working in the City of Pittsburgh. So when we're looking at this, doesn't matter where the business is located. We're looking at where the employees are doing the work. For Allegheny County, you can breathe a sigh of relief if you have less than 26 employees. So if you had 10 employees and only one is floating around downtown or in the Allegheny County working, you're not going to be covered by the Allegheny County law. if you are a business that has one employee floating around the city of Pittsburgh, it doesn't matter your size, you're covered under the city of Pittsburgh law. So in any event, both of these laws, when they're calculating who are the employees, we're looking at the number of employees in the last 12 months. And we use the highest number that you've had in that period. So maybe you had an aberration over Christmas because you had to hire a lot of people for all the shopping, and you had 50 employees that month, but all the other times you have 10 employees. They're going to say you're covered because you had 1 month where the highest number of workers was over the 26. So something to just be aware of, that we're looking at the last 12 months and we're looking for the month where you had the highest number of employees to know whether or not you're covered. Okay, let's go through a couple of examples. So we have ABC Corp. I know, fancy name. They have 75 employees total. 70 employees work exclusively in Butler County. Only 5 work in Allegheny County and in Pittsburgh. They are a covered employer under both laws, under the Allegheny County one and the Pittsburgh Sick Day Act. We have another company also named ABC Corp because I'm just that creative. They're headquartered in Washington, and it maintains its only office there. It has 100 employees, but, and this is really important because this is so common these days, ABC, because of the pandemic, started allowing people to work from home. 2 of the employees live in Allegheny County, but not the city of Pittsburgh. They live up in Pine Township, we'll say. All the rest live in Washington County. The 2 employees in Allegheny County are remote workers. This company is covered by the Allegheny County sick leave law, but not the Pittsburgh one because those employees are not in Pittsburgh. So remote workers can trigger these laws for you. I see we have somebody waiting in the lobby of the meeting room. So let me try to let them in real quick. Okay, there we go. All right, we're back. Moving on to the last example here. When we look at whether we're counting employees, it doesn't matter if the employees are part-time or full-time. So let's say ABC has 30 part-time employees, all of whom work in Allegheny County or Pittsburgh, and who each work 20 hours a week. Some of you who are seasoned HR professionals, and I know we've got quite a few here, you'll say, oh, we're going to count those employees fractionally. So we only have 15 employees. They all work 20 hours a week. No, that's not the way this law works. It doesn't matter if the employee works 1 hour a week or 100 hours a week. You count them as one for purposes of determining whether or not you're a covered employee. How they accrue the benefit is different. But for purposes of whether or not you're a covered employee, each one, no matter how many hours they work, if they're on your payroll, they count as an employee. And in fact, the guidance out there seems to be indicating that even if they're just on your payroll but not actually working, like maybe they're out obviously on vacation or maybe a workers' comp injury or something, they may count that person. So I see we have a question here too. And I apologize, I'm flipping between screens because we're trying to get the Q&A to work here. So let's see the question here. All right, so I actually have a few questions. So let me take a moment to answer these because I like to try to answer these in real time if I can. So what are the current priority zip codes? So the only 2 zip codes that we're aware of for the food service industry is 15201 and 15203. That's where the city of Pittsburgh said they were starting with that industry. What about small dental practices and small medical practices? There's no exception for the type of business that you may be in. Nonprofits, educational institutions, just about everything is covered except state government because the county government or the city government cannot regulate the state. But if we put aside the state and federal government employees, it covers everybody else, assuming that you have the right number of employees, assuming you have For the city of Pittsburgh, one person floating around the city of Pittsburgh doing some work. For Allegheny County, you have to have at least 26 employees. So you might be exempt if you're small enough from the Allegheny County law, even if you have one person in Allegheny County. Somebody asked about seasonal employees. Let me hold that question just a second because we will get to that later in the seminar. So, Angie, if you don't mind, we'll just hold that a second. Goodness, I'm so glad people are asking questions because this will make it a better learning experience. What about casual employees? They're still an employee. It doesn't matter about your classification as to part-time, casual, full-time, whatever, exempt, non-exempt, doesn't matter. They count as one employee if they're on your payroll. How do you know what zip codes fall under this requirement? So if you go to the city of Pittsburgh, so Allegheny County, it's anything within the borders of Allegheny County, and that's well defined. The city of Pittsburgh has a list of zip codes on their website, and that you can find in the, if you go to the website link for the city of Pittsburgh, it's there, and it talks about that. Let me see here. With regards to counting a remote worker and eligibility for the Pittsburgh Sick Leave Act, if the person comes into the building located in Allegheny County, but not the city, if the employee works from home located in the city 2 days a week, does that mean the company is on the hook for the Pittsburgh Act too then? Yes, it does. So that's a great question. Let me rephrase that because I was half muttering to myself when I was reading that. So the question, and this is a fantastic question because it deals with remote workers. If you have a worker who comes into the office maybe 3 days a week that's in Allegheny County, but maybe the office is in Warrendale, and so it's not in the city of Pittsburgh. Yeah, I live north. That's why I'm picking all the northern townships here. But 2 days a week, they live in the city of Pittsburgh and they work out of their house. You are on the hook for the city of Pittsburgh sick day leave law. However, if you're already covered by Allegheny County sick leave law, they're virtually mirrors of each other, so it shouldn't be more of a burden for you. But if you weren't covered by the Allegheny County sick leave law and just found out you're covered by the Pittsburgh Sick Days Act, then yes, you're going to have an additional burden on you to make sure you comply with that. All right. Let me move on to our last example. I have a ton of questions here. I really appreciate everybody chiming in here. Let me get to our last example, and then we will go back to these questions. Okay, last example. You have 5 employees, one in Allegheny County who's also in the city of Pittsburgh, one in Allegheny County that's not in the city of Pittsburgh, and 3 in Butler. Are you covered? Yes, you're covered by the Pittsburgh Sick Day Act, but the cap on the employees accruing hours is only 24 hours for the whole year, not 40, as it would be the case with an employer with 15 or more employees. You're not covered by the Allegheny County sick leave law because you're just too small. We will talk about the only person who's going to accrue hours in this example, and we'll talk about this more, is the one who's in the city of Pittsburgh. The other 4 employees will have no rights under the Pittsburgh Sick Day Act, only the one who's actually working in the city of Pittsburgh. All right, let me go back to some of the questions here because these are some really great questions. Somebody said, I just want to clarify, if you have one employee who makes you qualify as eligible for either law, the entire population of the company is covered no matter what state they work in, unless they are covered by a better law where they work. No, that's not quite correct. So, and I'm going to try to clarify that. First, we look at whether or not you are a covered employer. You're a covered employer, but the only employee who will benefit from that is the one employee who's working in either Allegheny County or the city of Pittsburgh or both. So if you have workers who are in Montana or Idaho or Erie County, Pennsylvania, they're not going to get the benefit of this law, but you will be a covered employer because of the one employee, which means as a covered employee, you have, and covered employer, you have certain obligations involving posting notices, having the right policy, tracking hours, which is what iSolved is here for, and CTR. Get a little plug in there. That one employee is the only one who will benefit, but all the obligations of the law are on your shoulders, including you can be investigated, complaint can be filed against you, etc. So I hope that helps. That's a really important distinction. I hope that helps. You're a covered employee, but not all of your employees will get the benefit of this law. Okay. The second question is along the same lines. If you have 5 employees in Allegheny County, do the rules apply to all employees in the company or only those specific employees? Only the specific employees. You are a covered employer, which means you're subject to the whole law, all the posting requirements, notice requirements, tracking requirements, etc. But only those 5 employees will get the benefit. Okay, we had another question along the same lines. So somebody else asked, say the main headquarters is in Chicago and a site is in Pittsburgh. The folks in Chicago will count towards your head count of whether you're a covered employer, whether you meet the 15 or 26 threshold. But if you have at least one person in the Pittsburgh office floating around, you're a covered employer, even though your headquarters is in Chicago, which I love Chicago. I used to live out near there. You're covered. You have all the notice obligations, tracking obligations, et cetera, et cetera. Only the folks in the Pittsburgh office who are actually doing work in Pittsburgh will get the benefit of the law. Okay, can you recommend an audit checklist HR can use at various sites to ensure that we have all the required notices for PA, Pittsburgh, and Allegheny County? So I'm going to be biased here. CTR does offer a product ensuring the notices, not just for the county and city, but for state, federal, et cetera, because they always change. And I know HR people love it when you have to put up new notices all the time, but they do always change. So that is a service that CTR does offer. You can talk to your contact here about that. But that is something that's out there for the specific notices for the city of Pittsburgh and Allegheny County. If you look at the websites, again, I provided those links. They have model notices on there that you can get for free too, if you only want the city of Pittsburgh and the Allegheny County notices. And we'll get to the posting requirements, but just to give you a heads up, you have to post them in English, Spanish, and any other dominant language in your workplace. So if you had a workplace where a lot of the workers speak Chinese, you would have to get it translated and hang it up. All right. So another question here that we're going to cover in a second. So I've put off the person with the seasonal, and somebody asked about PTO policy. Give me 1 second and we will cover that as well. All right. I think I went too far there. Okay, when we're counting people, I also want to point out a couple of things that comes up routinely. So you don't count owners. So if you're right on the fence as to how many employees you have, whether it's that 26 mark or the 15 mark, you don't count owners. So that can be helpful to you if you're just about on the threshold. You can see my example here is a company that has 25 employees and 1 owner. They wouldn't be covered by the Allegheny County law. They would be covered by the city of Pittsburgh, assuming that they're located or that they have employees located there. What if you have multiple companies? So both Allegheny County and the city of Pittsburgh gave a little bit of a wishy-washy answer to this question. What if you have multiple companies? Do you count them all? We have 10 in one company and 20 in another and 50 in another. And the answers for both of them was not necessarily, which is not the greatest answer from a government agency that I've ever seen, because it leaves some wiggle room there. But basically what they said is it depends how you have structured your companies legally, whether there truly is separate entities or not. And I'm not and never have been a corporate lawyer who structures companies. But what they're looking at essentially is, do we have separate legal entities, separate corporations, separate corporate minutes, separate whatever? And it doesn't have to be corporations. You could have separate partnerships or whatever it might be. But that's what they're looking at. And that's a very fact-intensive inquiry for each company. But if you're in that situation where you say, well, I'm not in the city of Pittsburgh, I'm in Allegheny County. I have 5 employees in this company. I have 10 in this. I have 20 in another company. Am I covered or not? You really want to take a close look at that to see if all of your companies will be counted as one, or if you have the correct corporate barriers or correct corporate structure up so that company A truly is separate and apart from company B and company C, even though there's common ownership. So very important to look at. Okay, so we have another great question here. Our company is located in the city of Pittsburgh, but there are several employees working in Ohio. Would the company be required to give sick leave to the Ohio employees? If all of their time is in Ohio, no, you're not required to give it to them. But we'll use some examples where an employee works part of their time in let's say Ohio or Butler County, and then part of their time in the city of Pittsburgh. Maybe they come in one day a week or one day a month. You actually have an obligation then to that employee who's coming in, one day a month for a meeting in your Pittsburgh office to start tracking their hours for purposes of this, and they could accrue enough time. If I work 8 hours a month in Pittsburgh, pardon me, in about 4.5 months, I will have earned 1 hour of paid sick time, which doesn't seem like a lot, but it's your obligation to track it and give it to me if I need it. Okay, moving along again. So you also don't count, this is the person who asked about seasonal employees. You don't count them. So you don't count independent contractors or seasonal employees. So in my example, we have a company that's located in Allegheny County and Pittsburgh, and it utilizes 10 independent contractors, 30 seasonal employees, and has 20 regular employees. It would not be covered by the Allegheny County sick leave law. It would be covered by the Pittsburgh Sick Days Act. But there's some really critical caveats here. Okay, so now is not the time to rush out and reclassify everybody as an independent contractor. First of all, we touched on this at the compliance seminar 2 weeks ago about new regulations and the DOL regulations that just came out about a new independent contractor test. And my comment then, and again, these webinars are posted so you can go back and look if you want. But the new test, the current administration is not in favor of independent contractor relationships and feels that most workers are probably better classified as employees. And that tends to be a pendulum that swings depending on which party is in office. And I say apolitical, but we see that back and forth tension over the years as to who is or is not an independent contractor. Right now, independent contractors are disfavored. And again, we covered who is an independent contractor, what that test is, what an independent contractor should look like in the webinar from 2 weeks ago that's posted. But if you have a worker who really should be classified as an employee and not an independent contractor, these ordinances are the least of your problems, right? You have tax issues, you have employment law issues, you have benefit issues, you have a whole parade of evils and these laws. But you need to make sure you got them classified right. Second, to be a seasonal employee under either of these ordinances, you have to give the employee written notice when they start. Okay, the Allegheny County law says you got to give them their starts and end dates at the inception of the employment agreement in writing, and it has to be less than 16 weeks. If you don't do that, if you blow it and don't give them the written notice, then all of a sudden they're a regular employee and they're not going to count for the seasonal exception. Don't get myopically focused on these laws and forget about other labor laws. If you give somebody a letter saying, hey, you are our new seasonal employee, we hired you just for the summer because that's our only busy time, is going to start May 1st and end August 31st, don't forget to put in their language that this isn't like a guarantee of employment, because you don't want an argument if you fire them halfway through because they never showed up, that somehow you had a guarantee of employment out there for them. One of the questions that's sort of unanswered out there is how we're handling employees from temporary agencies. I don't have a great answer on that for you. Under other labor law, they're viewed as joint employees, so I suspect that we will have an obligation to them. But the question is, whose obligation is it going to be? Is it going to be the place where they're working at or the agency that sent them? And that may be something contractually you want to work out until we have better clarity from the city or the county as to who's going to be responsible for tracking their hours, knowing how much time they have, and then paying that accrued sick time if they take time off. Okay, a couple more questions here. Does this requirement apply to student interns? Excellent question, and something I have not covered in this webinar, but I can give you some parameters for. So it doesn't cover internships that are registered with or through the U.S. Department of Labor. Most internships are not, don't fall into that category. So most student interns are going to be considered your employee, unless you're able to meet that relatively high standard of having a DOL recognized internship. So great question. If you're located in Allegheny County, but not the city of Pittsburgh, if you work in the city of Pittsburgh, would you fall under the PSDA or is it just the PSL? I'm going to go crazy with these acronyms. Okay. I'm old and these acronyms are killing me, even though I'm the one who came up with them for the seminar today. So the answer, that's a great question, Lauren, and I appreciate it. So let's focus on this for 1 second because it's a great example. You have a company located in Allegheny County, but not the city of Pittsburgh. The company apparently has enough employees to be covered by the PSL. So they're covered, those workers are covered under Allegheny County. But you have one worker who is floating around the city of Pittsburgh doing something. Maybe they're making deliveries down there. Are you covered by the PSDA? Yes, you are. It just takes one employee working within the boundaries of the city of Pittsburgh to trigger the PSDA. So what this would mean for this employer is they would have to have both the county and the city notice up. They'd have to have a policy that addresses both of them. They'd have to have a tracking system that accounts for both, which really these laws mirror each other. So that shouldn't be difficult, but the notices are different. So those notices that you put up on your friendly little bulletin board, you're going to have two of them, and they're each going to be in English and Spanish and any other predominant language within your workplace. So great question, Lauren. I hope that clarifies it for you. Going along here. Let me make sure I didn't miss a slide here. Okay, no, I didn't. Okay. All right. So this is a concept that so many of these questions have asked about, and it's worth repeating. Only work that's done within the geographical boundaries of Allegheny County or the city of Pittsburgh counts in terms of how people accrue the time. So when somebody asked, well, what if I have my headquarters is in Ohio, or I'm sorry, my employees are in Ohio, but every now and then one of them comes down to the city of Pittsburgh. I think I got the question wrong. Let me repeat it. They had some employees working in Ohio, but every now and then they might come to the city of Pittsburgh. So only their time spent in the city of Pittsburgh or in Allegheny County is going to count towards what they accrue. So the work, the actual 35 hours, which gets an employee 1 hour of paid time off, has to be within the Allegheny County or city of Pittsburgh. So if I'm that employee who spends 95% of their time in Ohio and only comes in for a meeting once a month for 8 hours in the city of Pittsburgh, Allegheny County, I accrue based on that 8 hours of work within the geographical boundaries of the city and the county, and not based on that other 95% of the work. So I'm going to accrue time extremely slowly, right? 1 hour for every 35 hours. It's going to take me about 4.5, maybe 5 months to accrue that first 35 hours. So by the end of the year, I might have accrued 2 or 3 hours of paid time off, which I can carry over to the next year if I haven't used it. I'm accruing it very slowly, but you are a covered employer. You have covered employees that you need to have posters up for, that you need to have a policy for, that you need to track their hours for, and that you need to give the time off to in a paid fashion. If, it come December, I have 3 hours of paid time and I say, gosh, I have a dental appointment, or my grandma has a dental appointment. We'll get to who all is covered because it's pretty broad. You need to give me that time off. Okay, let me finish this slide. I see I have more questions as well, but let me get to those in a second because I do want to be respectful of everybody's time here. All right, so some examples here. If we have, this is pretty much the example I just went through. Emily, employee, works in Beaver County, which is the headquarters, 4 days a week. She's in the office Friday in Allegheny County, Pittsburgh, and works 8 hours a day. Only the hours worked in Allegheny County or Pittsburgh will count for accrual purposes. So she's going to get 8 hours every week, basically. And so in about 5 weeks, she'll earn 1 hour of time off, paid time off. Butler County Company has a delivery driver who works all over Southwest PA. Usually on Tuesdays and Thursdays, he spends 4 hours each morning in Allegheny County / Pittsburgh. Only those 4 hours on the 2 separate days will count. The rest of his time doesn't count for accrual purposes. He's covered, though, even with this very intermittent contact. Now, somebody who just drives through, I leave Butler and I'm driving to Washington County to make deliveries, we don't count them. So that, even if they stop for their own convenience or just to get gas or a drink or something in Allegheny County, it doesn't matter. If basically it's just a transitory thing where they're just driving through, we're not going to count that person. This does become an issue, though, for this driver who's intermittent, or any employee who's intermittent in Allegheny County or the city of Pittsburgh. How do we track their hours? Both ordinances make clear that we can have the employee track their hours, their own hours, and report back to us. It's ultimately our obligation to record those hours, make sure they seem right to the best of our ability, and have it in a format that we can track it, know how much time off they can have. And like to have the employees track their own hours and then report back, because if someday they say to us, oh, I didn't work 4 hours in the city of Pittsburgh, I worked 100. We say, well, gosh, this is in your writing, isn't it? This is in your login on your computer. You're the one who told us it was 4 hours. Did you lie to us? So sometimes it's good to have the employee keep their own time so that they have a hard time arguing later that the hours were somehow wrong. Okay, a couple more questions here. And I really appreciate these questions. This makes it such a better learning experience. Okay, someone says, I have ascertained we are a covered employer. We do not separate sick leave and personal time. It's all paid time off for our Pennsylvania and U.S. remote staff. Would we need to change this? Okay, so let me get to that question. This goes with the PTO question. We'll talk about if we already have an existing PTO policy in a second. Another question is, what if a Pittsburgh company and deliveries are all outside or partly outside the area? Because the base is in Pittsburgh, does it all count? No. So only the time spent in Pittsburgh or Allegheny County. So let's flip the situation, because that's a good question. Our home base for our truck is in Pittsburgh. So in the morning, we spend an hour loading the truck. And then the rest of the day, our driver is out in Washington County making deliveries. Only that 1 hour spent loading the truck in Pittsburgh counts. And it might get difficult to keep track of, but you do have to keep track of. What if it's only 15 minutes picking up the truck and loading it and whatever? You still need to keep track of that. Okay. All right. So somebody else asked and again, we'll cover PTO in a second, but you already have a sick leave program that's richer than the county and city programs. Would this address employer liability? To a certain extent, it does. And we'll talk about why sometimes it won't. First of all, you need the notices posted. That usually doesn't come with a standard PTO program that most employers have right now. Second, the reasons that folks can take a leave under this policy is extremely broad and is broader than most current employer PTO policies. And we'll talk about that more. Somebody else asked, can the accrued sick time, if unused, be rolled over to the next year? If so, is there a limit on the hours that can be rolled over? Yes, it gets rolled over. The limit is either 40 or 24. So depending on the size of employer. But yes, it gets rolled over. So if I had 40 hours this year and I used 8 of them, so I had 32 left, those 32 can roll over. All right. So, and that goes to our next sort of question here. When do they start accruing time? When they're hired, but they can't use it until 90 days after the inception of employment. That's under both of the laws. So you should look at how this compares to your probationary periods. Make sure that you don't have something in your probationary period. If it's longer than 90 days, it says something about you can't take leave. Because some companies do have a 6-month probationary period. All right. We sort of covered how it's accrued. It's accrued 1 hour for every 35 hours worked within the geographical territory, up to either 40 or 24 in a 12-month period. There is some incentive here for the employees to use it every year, because if they roll over 40 hours, they can't earn any more the next year. You can always be more generous than what is required under this law. So if you want to give your employees 100 hours off every year, more power to you. I have a resume. I'll give it to you. No, I'm kidding. You can always be more generous. Exempt employees are presumed to work 40 hours a week. They might work more, but they're presumed to work 40 hours a week. So when you're looking at their time off, you need to be aware that that is built into the laws. You can front load the hours, which makes it easy in some ways rather than tracking hours. So I could say every January 1st, every employee has 40 hours or 24, whatever my requirement is, or more. And they can use it. That means I don't have to keep track of hours, right? I've given them all their hours. The problem with that is it works better in some industries than others. Some industries have a lot of turnover, lower wage earners, people who perhaps are less responsible. And if you give them 40 hours up front, they'll use it the first week of January and you'll never see them again. Some industries, it works really well, and it's a really great solution. It simplifies record keeping. It makes you compliant. You still have to hang up the notices and stuff like that, but it makes you compliant. Note that you can do it within an organization for some folks and not others, as long as you do it the same within a category. So you could say, hey, all exempt people get front-loaded 40 hours. Non-exempt don't, because maybe there are higher turnover, less reliable, whatever it might be. All office workers or all get it, but not our factory workers. You just need to be consistent so that you're not picking and choosing individually, so that you don't have 2 office workers, Ann's one and Joe's another, and you let Ann have the hours but not Joe, and they're in the same job, and now you have a discrimination type of action going on. Okay. Yes. So somebody asked, did I say, is there a limit to how much sick leave can roll over? Yes. So depending on your size, it's either 40 hours if you're over the 15 or 26 employee mark, or 24 hours if you're under the 15 employee mark for the city of Pittsburgh. Okay, so somebody else said, I thought if you pre-accrued, I think you mean front-loaded, the full 24, 40 hours, you didn't have to roll over the unused portion. That's true, because you're going to give them, if you're talking about front-loading, if I front-load every January 1st, 40 hours, I don't roll time over because I get a new 40 hours every year. And the maximum is 40 hours anyway, or 24. So yeah, you're not rolling anything over in that situation. I hope I'm interpreting that question right. Let's see. Okay, I think I've got up to date here everybody's questions. All right, how do you figure out what they get paid? Okay, if the link is not working, we'll work on that to get that working. It may just be the format that it's in right at the moment. You may have to type the link in. But if the link to the Allegheny County website isn't working when you click on it, we can either type it in or we'll try to redo it for when we send this out. Thanks for pointing that out. All right, for the rate of pay, you're generally just going to use the rate of pay that you pay them all the time. They don't get tips or commissions. If it's a piece rate, there's a way to calculate that. You're essentially going to divide the total earnings by the total hours worked in the most recent work week and figure it out from there. If they have fluctuating pay, there's different ways to figure that out. For instance, if you have a shift differential, right? People who work the midnight shift get an extra 50 cents. If you know they were going to work the midnight shift when they called off, then you know you're going to pay them that shift differential because that's the shift they would have worked. If you can't identify what the fluctuating rate would have been, you're going to do calculations to figure out the average hourly rate of pay in the current or preceding 30 days, whichever is higher. This law always gives the benefit, both of these laws give the benefit to the worker. So there's ways to figure this out. If you say, gosh, we have a fluctuating work week, you cannot cut off their benefits somehow. So it doesn't work that way either. Don't COBRA them for health insurance. You're going to keep that going. Reasons for use. So for those of you who asked about your current PTO policies, why can't we just use those? You can, right? You absolutely can. The problem with them, and they may be richer and better than what these two ordinances require. The problem with most current PTO, sick, vacation, whatever you want to call it, policies is they are not broad enough. So you need to review your policy to make sure the reasons for use are as broad as what's required by these ordinances. So for the employee's own medical care, injury, illness, etc. Okay, that would be under a standard PTO policy as well. Care for a family member. That often falls under a PTO policy as well, although the definition of family member, and we'll get to that in a second, is much broader under these ordinances than what most people would anticipate under a traditional PTO policy or under the FMLA if you're covered by that. So if you're sitting there saying, hey, I'm covered by the FMLA, I have to give time off, for anything, well, not anything, but, family member illnesses, the FMLA's definition of family member is much more narrow than these two ordinances. Closure of the employee's business by public order, or if there's a health emergency, think pandemic, right? And you need to take time off for a child because that child is sick and can't be in school or whatever, or their school or place of care has been closed because of a public health emergency. All of that is covered. And if you look at typical PTO policies, they often don't have language like this. A quick fix to those policies is to say, we cover time off for whatever you have in there already, plus any reason that is allowed to be used under the PSDA or the PSL. So very quick fix for your policies to simply put in that language and say, we cover it for these things plus any reason you could take leave under these two ordinances. Definition of a family member. Here's where we go awry or astray from what is under the FMLA or under almost all PTO policies. So you get the idea of a biological, adopted, or foster child, stepchild, or legal ward, a child of a domestic partner, or child to whom the employee stands in loco parenti. That's actually consistent with the FMLA. So those of you who are FMLA employers, anytime we have what's called in loco parenti, in other words, I may not have a real biological or adoptive or foster relationship to a child, but I stand in place of their parent for some reason, I'm probably going to have FMLA rights, and I certainly have rights under these two laws as well. Any parent, including a step parent, which is not necessarily true under the FMLA, or a legal guardian of the employee's spouse or domestic partner. So that goes well beyond what we typically see in PTO policies, or somebody who stood in loco parenti to me as I was growing up. A grandparent or spouse or domestic partner of a grandparent. That is much broader than what we see under the FMLA or most PTO policies. Grandchild, usually that's not covered. Siblings, not covered under the FMLA, right? Typically not covered under PTO policies. Could be, but usually we're not that broad. Or any reason that the employer allows the employee to take leave for. So for those of you who are sitting there that say, hey, we have a great PTO policy, we give 60 hours, we front load it, I don't have to worry about this Mickey Mouse business. I can't believe I just spent the last 45 minutes listening to Ann dribble on about it. Yeah, you are in the right ballpark, but you need to add some language to that policy to make sure it's clear that you're going to allow that time to be used for reasons that are probably broader than what's in your PTO policy right now, or your vacation or sick or whatever. All right, let me answer a few more questions here. So when rolling over, do you account for hours? Whoops, my questions just went too far. Okay, let me take this one instead. They should continue to accrue at the next level, so the hours worked all roll over to the next year. I think that's all part of one question. Let me try to, give me 1 second here as I struggle with technology to scroll up here a second on these questions. I'm getting so many. Okay, when rolling over, do you account for hours worked towards the next accrual? For example, someone has worked 60 hours, they've only accrued 1 hour. What happens to the additional hours? So each time they hit 35 hours, they get 1 hour. So in your example, they've earned 1 hour and they have 25 hours. Yes, going into the next year, that will count until they get the next 10 hours to make it a total 35 hours, and then they'll have 2 hours. So you'll roll over the 1 hour into the next year, and then you will have 25 hours that you're sort of counting towards the next 35-hour mark. All right, if you give 7 PTO days and an employee calls off 5 times for any reason, and PTO is automatically used for those days called off, would this comply with the PSL and the PSDA? So I'd make sure your policy is clear that that PTO time can be used for any of the reasons in the PSL or the PSDA. I'd also make sure it's clear that this is what you're doing. And then I think we have 7 PTO days, but they're calling off 5 times. If you have some sort of automatic termination or something like that after 5, I think you're going to have to relook at that. You can't just automatically terminate the person because they might need the full 7 days if they have earned or accrued that much, or you front loaded it. So I'm a little fuzzy on that question as to whether or not after 5 days we have a problem there. But yes, you could do that. They could be used for that. The caveat here, and we'll get to how you use this time, is let's say the employee only needed an hour. You can't necessarily force them to take the whole day as a PSL or PSDA day. Okay. Can you pay out the unused sick hours? In Pennsylvania, you don't have to. Allegheny County and City of Pittsburgh, you don't have to pay out. So there's no requirement, but yes, you can if you want to. You can always be more generous than the law requires. When did these changes go into effect? These laws were in effect in 2021. And there was about a year for both of them where the governing authorities that were enforcing them said, hey, we're just going to educate people. We're not going to like hit the employers over the head with a hammer. Those 1-year grace periods have passed. All the fines are applicable. All the enforcement is applicable. And of course, the reason we're doing the seminar today is because the city of Pittsburgh actually came out a week or so ago and said, we're ramping up enforcement, and if there's a complaint filed against an employer or we find violations in an investigation, we're going to strictly enforce these rules against the employer. Can we pay sick hours and yet penalize employee with attendance points? Great question. No, you can't. That would be retaliation under these laws. And so assuming that the reasons for the absences comported with one of the available reasons under these laws, right? It isn't just that I decided to go golfing. Yes, if I decide to go golfing and just blow you off as an employee, sure, you can give me attendance points. But if I stayed home to care for my sick kid, or my sick grandparent, or whatever it is I'm doing, or go to the doctor myself, you cannot give me attendance points. All right, let me get back to some of my slides here, because I know we're running close on time and I want to be respectful of everybody's time here. And then I promise I'll get to all the questions at the end. All right, you need a written policy if you want employees to give you advance notice of their need for leave. You cannot require that the employee provide it to you in writing. Verbal notice is enough. If the leave is foreseeable, so in other words, I know I have a dentist appointment next week. The employer can ask for up to 7 days advance notice, and the employee should make a reasonable effort to do so and to schedule things so as not to unduly interrupt the employer operations. If the leave is unforeseeable, I wake up, I'm ill, I get in a car accident on the way to work and I'm injured, then the requirement as soon as practical, preferably 1 hour before the shift starts if possible. But note that even with foreseeable or unforeseeable leave, if I, the employee, blow it, and how many employees are likely to blow it? Probably a lot. I still get to use the time and you don't get to penalize me. So just keep that in mind. And let me get to my slide here. All right, increments of leave. So the question about we're going to make them take a day of leave if they call off. Both ordinances talk about using leave in small increments. The Allegheny County leave says, hey, the smallest increment that your payroll system uses to track other leave, right? Think about FMLA. You're required to track that in the smallest increment possible, usually not more than 15 minutes. Certainly not more than an hour, according to the PSL. So I only need an hour off for the doctor. You can't make me take the whole day. A covered employee, same thing in the city of Pittsburgh. They're saying you use the smallest increment also to track their leave. Documentation, right? Now this is different than most people's PTO or FMLA or other policies. So you can only have documentation from a healthcare provider if the absence is longer than 3 days, 3 consecutive days. And then you can only require a generic notice. So if I bring in a notice from my chiropractor that says, hey, Ann was out due to a health condition, you can't get clarification on that. You can't get any better notice than that. You can't find out what my health condition is. These ordinances are trying to keep employers from being too nebby, as we call it in Pittsburgh. However, if you're running FMLA simultaneously, which could definitely happen here, it's not going to affect your FMLA rights. So as an employer, you can still, if this leave is turning into a long leave, you're still going to run FMLA if it's an FMLA qualifying event, and you can still get the medical certifications, and you can still have your right to clarification or a second or third opinion if you need to. Okay. Current policies, again, be sure they're broad enough. Be sure that how you use the leave is consistent with the smallest increment possible. If you have a collective bargaining agreement, in other words, you've got a union floating around, and you say, gosh, we have a leave policy in the CBA, but we need to tweak it to make sure it's compliant with this, that's a call to your labor attorney, because you can't just unilaterally tweak a CBA. You have to talk to the union about it. You have to open up the contract or get a memorandum of understanding or whatever it might be. That is something you want legal counsel involved in. All right, FMLA, again, we're running out of time, so I'm going to breeze through this a little bit. You have different rights there as an employer. After 3 days, you can ask for a note. You might also have the FMLA certification. The note for the PSL or the PSDA may be really crummy. But if they want FMLA leave, they're going to have to fill out those forms correctly. And I never take forms that say unknown duration or unknown whatever. I want clarification on that from the healthcare provider so that we can appropriately plan for the length of the leave. All right. Enforcement and retaliation. And again, I have a million questions coming in. I promise I'll get to everybody. I just want to be respectful of everybody's time. So we have the city of Pittsburgh. We know they're ramped up. They're ready to go. Your timekeeping and accrual should already have started. Obviously, for those of you who are clients of CTR, this is something we can help you track and keep track of. If you don't post those notices it's $100 per violation. What is a violation? Is it one day? Or is it each day that I don't have the notice of a violation? Is it one location or is it every location? What if I have 5 locations? The law is not clear on what is per violation. So be careful of those notices. Something very important under the PSDA, since they have ramped up enforcement, they tweaked their guidance to reflect some of the parameters that they're using to decide these complaints that are filed. And one of them is if you don't give them the records or if you fail to respond or cooperate, they have said they will have a presumption of noncompliance with the PSDA. That is really troubling if I'm an employer. So that's the hammer that they're using to say, hey, if you don't share your time records with us, if you don't cooperate, if you don't respond to a complaint or an investigation, then we have a hammer and we're going to just automatically assume you're guilty, which guilt is a criminal type of concept, but same idea that you're in violation of the law. And we're going to just find against you. So that's a problem if you don't have the right records or if you get one of these complaints and sit on it because you don't know what to do with it. There's obviously a prohibition on retaliation against the employee. So watch the emails, train your first level supervisors. They can't just get upset because somebody has filed a complaint. Consider if you have employment practices liability insurance, whether that will provide any coverage for you or not. And also note that the city of Pittsburgh is taking the position that if there's an adverse employment action against the employee within 90 days of filing a complaint, it's presumed to be retaliatory, right? It's not because they never showed up for work. It's because it's retaliatory according to the city of Pittsburgh. So be very careful of the retaliation claims given the city of Pittsburgh's guidance as to how they view that. All right, last slide here. Whoops. One real life example we'll do. We have Emily. She works in the city of Pittsburgh full time. So we'll assume 40 hours a week. She's accruing about 1 hour of time per week, a little over that. She's been with the employer for 5 years. She's a good employee. The employer has 30 full-time employees and 25 part-time employees. Emily, employee, tells her manager and close friend that she is suffering from back problems and lifting the boxes at work are killing her. She's seeing a chiropractor on Monday. What issues do we have? Don't look just at these 2 ordinances. If we had more time or we were in a seminar, I'd start calling on people. We have FMLA. This employer is large enough to be FMLA. We have a manager that I'm always harping on first level supervisors and their need to recognize legal issues so they run it up the flagpole. We hope and pray this manager tells somebody in HR because we have FMLA, we have PSL, we have PSDA rights here. We might have ADA. Does she have a disability? We're not sure. Do we have workers' comp? Not sure about that either. So I'm ticking off at least 5 laws that we should be looking at after we hope and pray that the manager reports this to HR. And certainly the time to see the chiropractor would be covered under the PSL and the PSDA and might be FMLA time too, depending on what's going on. It could be workers' comp. She might need some type of accommodation under the ADA if we find out that this is a disability. But those are the issues that we would be looking at as the HR person, because there's not enough on your plate. You need a few more things to do. And you can see there's a lot to work through. The easiest of which is actually the PSL and the PSDA. She's going to get that time off for the chiropractor. We can't make her use it in larger increments than, the smallest that we track for other leaves. So I appreciate everybody attending. I certainly understand if people have to hop off and enjoy their lunch. But let me go back through these questions and see if I can't answer the ones that have come in. And again, we do these seminars every second Thursday of the month, and always looking for ideas. So feel free. Everybody, thank you for attending, and I'll now get back to these questions. Okay. What are the ER penalties? I think you mean like what are the penalties? The penalties, the only if you don't post the notices, it's $100 per day per violation, or I'm sorry, $100 per violation. I don't know if that means per day or per location. They haven't defined that. Obviously, the bigger issue is if you've inappropriately denied somebody this right and then terminated them or disciplined them, you're going to have to retract the discipline. You might owe them back wages. There's damages from the employee, which are worse than the penalties. Okay, if our PTO policy is clear and complies with the PSL and PSDA, would we only need to put up notices, meaning we don't need to track their hours and accrue sick time? If your PTO policy front loads everything, then no, you don't have to keep track of the hours. If it does not front load the right amount of hours, right, then yes, you would still have to track and accrue the hours. So it depends on how your PTO policy is written. Okay, in the case of paying out, I'm assuming PTO time here, I just want to ensure it's not a violation of law, as it should not imply as we're encouraging not to use sick hours. Great question. That is a cultural issue as to whether or not paying out is a good idea or not. It is absolutely not a violation of the law to pay it out. I understand your concept or your point that, gosh, if we pay out PTO, people aren't going to use it because they want the money, and that maybe encourages poor health choices. That's a cultural or business decision for your company. But if you pay it out, there's nothing that prohibits you from paying out PTO. Just be clear that that's what you're going to do. And also think about, do you pay it out to everybody or only the people who give you like 2 weeks notice? Do you pay it out to the person that's terminated for cause? You might want to put some parameters around who you pay it out to. The most common parameter I've seen is you must give us 2 weeks notice to get paid the PTO because we want time to transition. It's an incentive to get that notice if they want the payment. But you don't have to do that either. Good question. Okay. All right. If you are a service industry and your technicians leave in a work vehicle for their regular 8-hour day, and it is not possible to allow our employees to use just 1 hour, what do you do? Can you require them to use a full day? No, you can't under the law. So I feel your pain with this question of how do we account for the person who just needs an hour and a half off, right? The law does not always, not just these two ordinances, but just in general, doesn't take into account every industry out there and the difficulties that you have with respect to the fact that you have somebody on the road out doing service calls. So no, the best solution is you're going to have to allow the person to say, okay, they only needed an hour and a half off. So maybe they work 8 to 11, 11 to 12:30, they're off, and then they're back on the clock at 12:30. It's not ideal, but you cannot require them to take more than what they need or the smallest increment that you use to track other leaves. So I am sorry to be the bearer of bad news. And I do feel your pain. It doesn't always match up with business. Law does not match up with business necessity all the time. How do we sign up to get these notifications of law changes for HR? So I'm hoping you mean the monthly compliance webinars. And if you liked it, that is just great. I hope you have enjoyed it, despite my quirky humor and the fact that, it's freezing outside and all that good stuff. So there's multiple ways. We had on the second to last slide here, there's a sales team you can contact. It's not high pressure. You can just ask to sign up for this. If you are a current client, you can obviously talk to your your contact here and sign up. But these are available to anybody who wants to listen in or who has insomnia, either one, and wants to participate in these. You can reach out to me as well. However you like, you can just call CTR and say, hey, can you add us to the list? We send out monthly reminders, save the date type of emails for these things, and you can pretty much count that they will be the second Thursday. We also, for like this one, sent out sort of an emergency save the date. Hey, we got something new, save the date. So just contact anybody here. You don't have to be a current client. Anybody, friends, family, whoever, welcome to join in. And by the way, I appreciate all these questions. Can we get copies of the slides? Yes, those will be posted. Just give us a little bit of time. The webinar gets recorded, and then it takes us a little bit of time to post everything, but it will be there. Okay, for salaried exempt employees, can the smallest increment of sick time used be 4 hours? No. So great question, but no, because that's probably, if you were like an FMLA employer, you couldn't require that either necessarily. FMLA, just like this, gets used in the smallest increment, and the PSL specifically says not more than an hour can be required. So at most, I think you're looking to say an hour at a time. And so maybe it's 2 hours, maybe it's an hour, maybe it's 3 hours, but no, being exempt isn't going to change that. All right. Okay, great question here. If the employees are at different places each day, say in the construction industry, but it could be any industry, do the notices only have to be the main office, or is it better to have them in the vehicles? So we don't have clarity on that under these two ordinances. It says at the work site. Now, you're not going to go out every day and post a notice at whatever work site it is. I would certainly take the position that the main office is the starting point, that you would post them there, where you probably have your other federal posters and state posters, wage notice posters, EEOC posters. Post them there. I don't think you have to put them in the vehicle, but we don't have specific clarity on that. Is there a way for employers to ensure the employees do not abuse it? As we know that many employees take it for other reasons towards the end of the year simply because they will lose it. So this is a question that comes up with FMLA all the time. How do we prevent that? And the reality is we don't prevent all of it. What I always recommended to clients was we look for the biggest abuser. And then if we have the resources and the financial resources to go after them, we do. And part of that would mean for like FMLA violations, we would actually send private investigators out to watch them to see if they were using the time. Like if they said it was for their own health condition, they shouldn't probably be out there baling hay or something, which is actually what we caught somebody on video doing. It's inconsistent with a back problem. But that takes a lot of sort of moxie on the employer's part and financial investment. But the idea is if you go after the biggest abuser, you hopefully keep everybody else in line. That, again, is a business decision that you have to make as to, do you think you really have a big abuser out there that you can make an example out of? But there isn't a great way. Unfortunately, there is a percentage of workers that will abuse this all the time. You hope most of them use it well. Okay, we upfront load the hours so we do not roll over. That's fine. As long as you're upfront loading sufficient number of hours, that is A-okay. What is the purpose of designating an accrual period, i.e. beginning 1/1 if the employee is allowed to carry it over into next year? So the law says you have to designate a 12-month period in which to use this. Most employers would use a calendar year. You don't have to. If for some reason it made more sense, like maybe you're a school, maybe you want to start at 8/1, all right? That's why you designate a period, so that when we look at your 12-month period, both for determining whether you're a covered employer, which you look back 12 months, but we're looking at that and saying, how many employees have we had? When did they use it? What is our 12-month period? This law actually gives the flexibility to the employer to designate a 12-month period that would be something other than 1/1 to 12/31. We let employees borrow up to 40 hours of PTO, even if they haven't accrued it. Does this cover us? So not really, because in this case, you would have to still provide the applicable time records to show what I have accrued. So maybe, let's just say your 12-month period is 1/1 to 12/31, just to make my math simple here. And I say on Wednesday, 1/18, I'm going to be out for the next 5 days. due to a small little medical procedure. And yes, you can get a note on that because I'm going to be out for 5 days. And have I accrued any time yet? I might have accrued about 2 hours already this year. You would have to have a record to show, hey, she accrued 2 hours, she's using 2 hours, but the rest of it we're loaning to her, which we can do. There's nothing wrong with that. But we still have to be able to document what was actually accrued and used under this ordinance. Okay. You know what? Thank you to everybody who's thanking me. That is very kind. It makes my day. I love doing these types of webinars and seminars, and truly, I appreciate all the questions today. It makes it such a better learning experience. Okay, so a couple of things. A couple more questions. Does C2R offer services to help employers update policies? We do have an HR service, so that is available. When you say the links will be posted, where are you referring to? So I am not the technical guru. In fact, I think CTR hopes I don't break my computer. I've already done that once. My understanding is they're on the website. If I'm wrong about that. Oh, also anybody who signed up for this gets an email blast. Can the notices be posted electronically? Currently, that's not permitted. And those are the notices for the PSL and the PSDA. They talk about posting in a work site. You can also post them electronically. That's a great idea, especially if you have employees who are out and about a lot. Are seasonal employees the only exception to the PSDA? No, independent contractors don't count, which they're not employees anyway. They're 1099, assuming that you've correctly classified them. And interns who qualify for a DOL internship, which is far and few between, are also not counted. But yeah, seasonal employees is the main one that you're looking at. And you only track employees who receive less than 40 PTO hours. So if you're front loading the PTO for the people you're not tracking, that would be fine. If you're not front loading it for them, then you have to track the folks who have the 40 hours of PTO as well. I think I'm at the end of the questions. And again, thank you to those who said thank you. Thanks for everybody attending. I hope that this was helpful. I love the discussion today. I hope I got to everybody's questions and answered them. And again, please join us. Give us ideas for other seminars. I would love to know what's on your mind so that I can cover it. Okay, I'm so glad people love these seminars. I truly enjoy them. So everyone take care and stay warm if you can. And hopefully we don't get the snow they're predicting tomorrow, because then I'll have all 4 of my kids home again. Okay, take care, everyone. See ya.